Welcome, ladies and gentlemen, to this panel entitled International Humanitarian Law and Cyber Activities. We have three very distinguished speakers with us today. This panel will run from now to 3 o'clock, and I've been told that I should strictly adhere to this time frame, so I'll be quite brutal in the way in which the panel is organized. We have three speakers, we have an hour and a half, so each speaker will be allocated 30 minutes for their presentation. I've encouraged the speakers not to speak for longer than 20 minutes, which will allow at least 10 minutes for each speaker to receive questions from the audience, perhaps questions from other panel members as well, and even from myself. We are all broadly familiar with what each other will be talking about, and I'm sure it's going to make for a very lively discussion. So thank you very much. The first speaker is Mr. Laurent Giselle, who is a legal advisor with the International Committee of the Red Cross. Laurent's biography, which demonstrates his extensive experience in international humanitarian law, is available through the conference website, so I won't repeat that unnecessarily. But other than that, it's very much my pleasure to welcome Laurent to the stage to give his presentation entitled International Humanitarian Law and the Challenge of Ensuring the Protection of Essential Civilian Infrastructure Against the Effects of Hostilities. Thank you very much, Laurent.
Thank you very much, Russell, and thank you to have invited me to speak at this conference. So I will talk about the protection of essential civilian infrastructure from a legal perspective. Of course, there are also many challenges from a technical perspective, but that's not my field. I will look at how the law, in particular how IHL protects essential civilian infrastructure against the effects of cyber hostilities. And I will try to deal with 6 points in the time allocated. A short introduction, then a general issue of interpretation of IHL that are particularly relevant for cyberspace, specific issue related only or specifically to cyber warfare, precaution against the effects of attack, legal review of weapons, and a few concluding remarks. So, as an introduction, of course, there are many cyber attacks every day occurring, but most of them are criminal acts which are related to peacetime and have nothing to do with armed conflict. So what I am talking about is operations against a computer or a computer system through a data stream when used as means and method of warfare in an armed conflict as defined in IHL. Now, why does ICRC deal with cyber warfare? We look at every new means and method of warfare, and we try to do three things: keep abreast of technological development in order to understand what is the potential humanitarian impact or the human cost of that technology, how it can be used and how it can have effects both on soldiers and on civilians. And then assess whether the law as it is clear and sufficient, or whether there is a need to work for clarifying the law, or whether there is a need to work for the preparation of development of the law. So that's what we do with regard to cyber warfare, as with any other new means and method of warfare. Cyberspace has great benefits in peacetime. It allows worldwide communication, it allows economic developments, plenty of extremely beneficial elements. Until now, there have been, fortunately, no widespread humanitarian consequences of the use of cyber warfare, but the military potential of cyberspace, so the risk of cyber warfare is not yet fully understood. So our concern is that potentially there might be high humanitarian cost of the use of cyber warfare. It's said that attacks against nuclear plants or chemical plants or transportation systems are possible. I have no idea whether that's true. Nothing about computer, I'm just a lawyer. But that's what is in the public literature, that this is possible, so that would be extremely concerning, of course. Operation against essential infrastructure, even if they don't lead directly to killing somebody, but if it interrupts electricity or interrupts the water network, would also be extremely concerning. Civilian infrastructure are often relying on cyberspace for their functioning, and cyberspace allow worldwide communication, which means also worldwide vulnerability. The civilian infrastructure that rely on cyberspace might be at risk of attack from anywhere. And the last, or the third concern, the third main concern is that cyberspace is used for both military and civilian purposes, and it's very much interconnected between the two aspects, which is a key challenge for distinction being the main rules governing the conduct of hostility. We discuss the challenges and a lot of what I'm going to talk about in the reports that is on your screen now, focusing precisely on the protection of essential civilian infrastructure that was published in October 18 months ago. And in a way, sadly enough, 2 months later, in December 2015, there was the first known cyber attack against an electricity grid in a situation of armed conflict that was in Ukraine. The electricity grid was attacked through a cyber operation, which led to loss of functionality, leading to 200,000+ civilians people being deprived of electricity for a few hours. I will come back to that example in the discussion. I will also, of course, mention a few of the rules of the Tallinn Manual 2.0, so the new edition of the Tallinn Manual, which we believe is a very important work. The ICRC has been an observer during the process that led to the first Tallinn Manual, which is republished in the Tallinn 2.0 Manual. It's, of course, an academic work, not a treaty and not a governmental or NATO doctrine, but it's certainly extremely important in our view. So, turning to some aspects of interpretation of IHL, which are general matters of interpretation of IHL, but particularly relevant for cyberspace, I will deal with two. The first one is dual-use objects. Of course, essential civilian infrastructure are primarily civilian objects. Electricity network, water network serve the civilian population in the first place. They are civilian object and not military objective according to the definition that you find in Article 52 of the first additional protocol, which is also customary. Now, one of the difficulties is that, as I mentioned earlier, essential civilian infrastructure often rely on cyber infrastructure for their functioning. And cyber infrastructure, many objects forming cyber infrastructure might be dual use, being used both for military and civilian purposes. So how does the law address that? The Tallinn Manual mentioned, and that's the traditional view, that infrastructure which is used for both military and civilian purposes becomes a military objective. Of course, provided that it fulfills the definition of the military objective, but it becomes a military objective. So the risk would be to consider that the entire cyber infrastructure is a military objective and can be targeted. We think that one needs to look closer before reaching that conclusion. The assessment needs to be object-specific and not cyber infrastructure in general. That's the same for roads, that's the same for electricity networks. You can't assess that the entire road network of the enemy country is a military objective. You need to look at which road, which bridge does fulfill the definition of military objective, and that's the same for cyber infrastructure. Then there is a particular aspect in cyber, which is it's built with an important element of redundancy in the system, in the sense that if a part of the network is blocked for data are immediately rerouted through another part of the network. So that raises the question of whether the operation that is planned would bring a definite military advantage according to the definition of military objective. If the only effect is that the data traffic is rerouted instantly through another path, then maybe there is no military advantage. Now, it will, of course, depend on the type of operation you do and the type of targets you might target, but that's certainly an aspect to keep in mind. And the third aspect is that even if a specific part, object, or specific network belonging to cyber infrastructure has become a military objective, but remains also used for civilian purposes, the incidental harm in terms of blocking the civilian use of that dual-use object, which has become a military objective, has to be taken into consideration for indiscriminate attack and disproportionate attack and precautions. The second point is the question of indiscriminate attacks. The Italian manual deals it with two rules, one on indiscriminate means and method, which are by nature, means and method which are by nature indiscriminate. There are two kinds, those which are directed, those which cannot be directed at a specific military objective, and those which cannot, whose effect cannot be limited as required by IHL. And then you have a second rule, which is on indiscriminate attacks, those defined as those which are not directed at lawful targets. Now, if you look at the treaty definition of indiscriminate attacks, the treaty definition of indiscriminate attacks actually, which is in Article 51 of the first additional protocol, prohibits attack, including those that use means and method of warfare that cannot be directed and whose effects cannot be limited. And it's clear based on the travaux préparatoires in the diplomatic conference in 74 to 77 on ICTY case law, and actually also in the commentary of the Italian manual, that this also applies when when it cannot be directed in the circumstances of the use, meaning that even if a weapon is not inherently indiscriminate, maybe an attack using that weapon might be indiscriminate. The example for kinetic world would be using unprecise missiles, like let's say Scud missiles in the desert. Nobody have ever said that Scud missiles are inherently indiscriminate because they could not be directed. But using Scud missiles under military objective located in a populated area is arguably use of a means which, in the circumstances of the use, cannot be directed at a specific military objective. For cyber, that would be, for example, a malware that could possibly be used discriminately against a closed military network, but if that malware risks spreading when it's used in the open internet and spreading out of the control of the user and affect also civilian networks, then using that same malware against a network linked to internet and not a closed network might be an indiscriminate, the use of an indiscriminate means, indiscriminate in the circumstances of the use. And why do I mention all of that? Because I've read military manuals who actually, not even like the Italian manual, have the rule 111, but only have the rules on the indiscriminate, on the prohibition of means and method which are indiscriminate by nature. So forgetting completely the fact that maybe they might be indiscriminate because of the situation in which they are used. So we feel that this is very important. This is very important for cyberspace precisely because of the interconnectedness. We are very glad that this is clarified in the commentary to the rule of the Italian manual. Of course, and that's the purpose of my talk, the protection of essential infrastructure will depend first and foremost on how IHL is interpreted in the first place. If it's interpreted with upholding the protection that IHL grants, of course, that will bring more protection to civilian infrastructure. Now, turning to two aspects which are more specific for cyberspace. The first one is the notion of attack. There is a debate on whether, so I'm talking on an attack as in Article 49 of the first additional protocol, not an armed attack under the UN Charter. That's a different issue. An attack on the first additional protocol, there is a big debate on whether a cyber operation leading to a loss of functionality is an attack under the rules on the conduct of hostility. The Italian manual expressed that the experts had four views. The first view is that there needs to be physical damage, so only loss of functionality is not an attack. The second view would be that if the restoration of the functionality requires replacing physical components, that's an attack, but only in this situation. The third one, if it requires the reinstallation of the operating system or particular data. And the last view expressed by the expert is that loss of an operation leading to a loss of functionality is an attack, irrespective of how you need to redo the functionality. And that certainly or position. It is immaterial how it occurs if an object is disabled. That's based on two arguments. First is the notion of neutralization in Article 52 of the definition of military objective that I had put on screen before, which would be superfluous if that was only destruction. And then also because an overly restrictive understanding would be, in our view, difficult to reconcile with the object and purpose of the rules. And let's come back to the example I mentioned at the beginning of the cyber operation against the Ukrainian electricity grid. Assuming IHL applies, because we don't know why the operation was done and by whom it was done, so there is no proof that it has a nexus to the conflict. But let's assume that IHL applies to that operation. In our view, that operation was an attack because it led to a loss of functionality and then needs to be analyzed for its legality, if IHL applies, as the prohibition of a direct attack on civilians, the objects, the prohibition of indiscriminate, disproportionate attack, etc. The result might be different if you have other views on whether a cyber operation leading to a loss of functionality is not necessarily an attack. Are data an object? I will actually be very short because I understand that Heather will speak much more longly about that. So you have some views in the Tallinn manual. I will just mention that our view, of course, is that medical data, and on that we agree with the Tallinn manual, are protected by the special protection granted to medical facilities and medical mission in general. So data which are part of a medical unit are protected as well, hospital data or patient data. Now, so the question is for other data. In our view, the position that deleting essential civilian data would not be prohibited by IHL is difficult to reconcile with the object and purpose of the rule. That might be, have much more widespread effect and important effects for civilians than the destruction of one particular object which is prohibited. So if one not so important object is protected, why wouldn't be all security social data, all the client's file of a company not be protected? Because if you destroy one truck of a big company, it's a violation of the prohibition of directing attack on civilian object. But if you, so what about deleting entirely its client's file? That would most probably bring the company to bankruptcy, while destroying one truck would not. So it makes, in our view, no sense that deleting essential civilian data would not be seen as protected. So again, the protection that IHL will afford to civilian infrastructure will depend on how IHL is interpreted, generally speaking, as I mentioned at the beginning, but also for the specific issues that cyber warfare raise. Precaution against the effects of attack, that's an obligation by the parties to the conflict, and the question is what is feasible? I think lots of IT companies already do lots of things in terms of protecting stuff, but the point here is what does state do or could do or should or must do in terms of protecting civilians under their control and civilian objects from the effects of hostilities. And this morning I was listening to the panel, the Cyber Commanders panel, and I was struck by General Fulmer saying, we are now an IT company providing security, and he was speaking of the military defending military networks. But in the kinetic world, it's the military who defend its stuff and its assets. So why would it be different in the cyber world? And I think military have realized that they need to defend their cyber networks. But I think states need to do also that step with regard to protecting civilians against the effects of operations. I just mentioned a few examples, there might be more. There might also be things which would require more technical innovation or cooperation internationally to think about how to make a digital emblem, I mean the identification of protected object in the digital space, or creating protected or demilitarized zone in cyberspace, or how we could analogize from them. That's of course more in terms of thinking for the future. Very quickly, weapons legal review. I'm not going to go into the details, but Article 36 requires that weapons, means, and methods be reviewed. The Italian manual have rules on weapons legal review, which says that customarily it's only for weapons. Now, for cyber, that's a good question. What is a cyber weapon as opposed to a means and methods? And in that sense, the US directive on the review of cyber is on cyber capabilities as opposed to weapons, despite the fact that the US normally review weapons. But to be on the safe side, in a way, the US decided that it would review cyber capabilities. And I think that's a very good step. Now, of course, there are some challenges. To make a legal review requires clarity on the law. To take the example of the functionality for an attack, you can't do a legal review of a weapon if you have not decided whether a cyber operation which leads to a loss of functionality is an attack or not. Because if what the tool that you are reviewing is leading to loss of functionality, will you review it against the prohibition of directing attacks, disproportionate attack, indiscriminate attacks, etc.? Or would you review it only against the less demanding rules and less precise rules of taking constant care to protect the population? So, of course, you need to have legal clarity. Then there are probably less standardized testing challenges, for example, in particular on the effects, the risk of spreading, and affecting other and getting out of your control when they are on the World Wide Web, because you can't test that without putting them on the web, and therefore it might be difficult. And then you might, more than with kinetic weapons, need to adapt the weapon to the technology. So, very quickly, a few concluding remarks. States that develop cyber military capabilities must ensure that they can be used in compliance with IHL. In that sense, the first step is to recognize that IHL applies to cyber capabilities. That's what NATO did a couple of years ago. Many other states did it, and that's, of course, very welcome. The UN group of governmental experts said that international law applies, in particular the UN Charter. They have not expressly said for IHL, but that's still one step. As I mentioned before, the Italian manual, although an academic work, is also extremely important in that regard. There have been some sensitivity, maybe not for people in this room, but in the wider world, let's say, on whether saying that IHL applies legitimize cyber warfare or encourage the militarization of cyberspace. That's certainly not the case. Anyway, any resorts to armed force, like whether kinetic or cyber, remains governed by all the restrictions that you find in use ad bellum. So, to sum up, the protection that IHL will afford to essential civilian infrastructure depend on how IHL is interpreted in general and for the specific challenges raised by cyber warfare, and of course, by compliance with IHL. Whether there is a need to develop the law, that's still something that the future will tell and states will decide about it. Thank you very much.
Thank you, Laurent. Thank you for providing a panorama of the ICIC's approach as to how international humanitarian law applies to cyber conflict. Just to kick off discussion, I have a broader question about the ICIC's perspective on how states are responding to the application of international humanitarian law to cyber conflict, particularly on the behalf of states and how states are responding. So in November last year, former legal advisor to the US State Department, Brian Egan, criticized states for not publicly clarifying how they interpret and apply international humanitarian law to cyber. And in fact, that was the reason Mr. Egan went on and praised the Italian manual for kind of stepping into the breach and providing clarification. So my question is, how does the ICRC view this reticence of states in explaining how international humanitarian law applies to cyber conflict? So to put that differently, does the ICRC see this reticence in providing clarification as a deliberate unwillingness? Are states trying to maintain a creative ambiguity as to how international humanitarian law applies, thereby preserving a grey area between legality and illegality in order to allow them to pursue military objectives in cyberspace that would be flagrantly unlawful if committed via conventional means?
We certainly think it's very important that states clarify that IHL applies, as I mentioned before, and that also they clarify how they interpret the law, because I said that's the only way they can do legal review of weapons. But that's could be done only internally in a classified manner. I understand your question as being more public on that, and we would certainly favor states being public both on the fact that IHL applies in the sense that the limits that are posed by IHL applies to and govern cyber operations in general, and then be more specific on exactly what is prohibited. Of course, we would hope that they have a protective understanding of the law and uphold the protection that IHL applies also, that IHL grants also in cyberspace, and precisely don't do what you suggest, that they would take the opportunity of these new means and methods to start doing things which would be otherwise prohibited. I think that's important for the purpose of the law, which is to protect civilians and civilian objects, I mean the rules on the conduct of hostility. So that's the primary purpose of the rules, and this needs to be kept in mind when the law is interpreted for cyberspace. I think it's also important that states says what is prohibited, because then they can also then publicly, I mean, they are publicly on the record that they will criticize another state doing that kind of operations. And that makes more clarity for everybody, I mean, for all parties to the states and parties to the conflict, and that's probably better in terms of both application of the law and decreasing the risk of escalation, because one doesn't know what the other thing is prohibited and does something, and then the other felt it was prohibited, so wants to take reprisals or not. Or so this lack of clarity is probably not good in terms of I mean, also increasing the risk of escalation in terms of cyber operations. So yes, we would be in favor that states are clearer.
But do you think states are unwilling to provide that clarification in order to deliberately create this area where they can perhaps act with this kind of plausible deniability?
I think plausible deniability is more linked to the question of attribution, which is certainly a big challenge for cyberspace. Cyberspace is built on anonymity, which makes attribution more difficult, and therefore makes plausible deniability also more easy. Now, that's heightened problem in cyberspace, but that's a problem, an issue which exists also in the kinetic world. Look at what occurred in Ukraine, and I'm not speaking of cyber, I'm speaking of the physical world. There have been allegations by the Ukrainian government that Russia is involved, and Russia denies it. So attribution might also be difficult in the kinetic world as in cyber.
Okay, thank you very much. There's opportunity for some questions. I see 1, 2, 3, so let's go 4. Let's go to, in order, let's go to Kubo, thank you.
Thank you, Russell, and thank you, Laurent, for your very interesting and very informative speech. I was really struggling keeping pace with everything that you covered, but I would actually push you on this issue a little bit further. So yes, we have the issue of the lack of legal clarity, but it's very much linked to the factual ambiguity that we face in cyberspace. And so, you know, you mentioned the Ukrainian context with the very important caveat, provided that there is a nexus to an armed conflict. The same can be said about the other conflict, which is often mentioned in this context, and that's the Georgian conflict, which was also accompanied by cyber operations. But even in an authoritative study by the CCD-COE, the conclusion was that the objective evidence does not support applying the law of armed conflict to the facts on the ground of these cyber operations. So to throw it back at you, how does ICRC deal with these factual difficulties when you come to resolving these legal issues when it comes to cyber warfare? Do you have some thoughts that you can share with us on that? Thank you.
I think attribution is a difficult issue. Now, for the person who carry out the operation, attribution is not difficult. So we should not overestimate the problem. I think it's an important problem, but it's a problem for the outside world, not for the operators. The operators know what it is doing and know whether that has a nexus to the conflict, and therefore know whether he or she must apply IHL. And that's what IHL is based on. The first responsibility to apply IHL is not on the ICRC or on criminal courts or on the UN, it's on parties to the conflict, first of all states. States and cyber commands or whatever, they know what they do, they know whether it's linked to an armed conflict. Now, what the ICRC does, we don't have a magic wand to attribute either. Now, fortunately, as I mentioned at the beginning of my presentation, there have been no widespread humanitarian consequences of cyber operations so far, so we have not been faced by a huge problem in that regard. That's not featuring as a primary topic of discussion in terms of operations which have occurred. It's much more a discussion like we have today on how is the law must be interpreted to be applied on cyberspace at this stage.
Yes, just over there, please.
Thank you. You mentioned that it would be helpful if governments would set out their own understanding of how international humanitarian law applies to conflicts. It's a nice idea. In practice, is any government really going to do any, even if that happened, going to do anything other than interpret it very conservatively so that they do not rule out their own capabilities? Plus, you have the show me yours before you show me mine situation. If one government comes out and says, well, we interpret it in this way, and they're effectively, potentially depriving themselves of capabilities and therefore providing an opportunity to their opponents, firstly, a vulnerability, and secondly, to declare, well, we interpret it differently and therefore we can exploit that vulnerability. And I think it is tied in also to the question of attribution, because whilst we have difficulty both in attribution and therefore in deciding whether a particular action falls within IHL or not, there is absolutely no incentive on a government to come out and say this is what we do or this is what we don't do and this is how we interpret it, because the two are completely interlinked. And as a legal advisor, I can't imagine anybody in their right mind would advise their government to voluntarily give up a capability by putting an interpretation on an area of law that's uncertain. So I think we're a long way down the road from there, and we need some kind of clarity, either in terms of an international agreement or some kind of international court decision before anybody is going to start making those kind of declarations.
I agree with you that the road is long ahead of us, and to take a discussion we had yesterday, it's now more than a century that there is air warfare, and there is no specific treaty regulating air warfare, and we are still discussing how the law applies to air warfare. So we will still discuss how the law applies to cyber warfare probably in a century. So the road is certainly long ahead of us. Now, works like the Italian manual are extremely useful in that regard. Now, to turn to what state does, there is an example that probably everybody in the room knows. That's the US have a chapter on cyber operation in the new US DoD manual. And on whether a legal advisor would advise a state to renounce capabilities, I don't see it as renouncing capabilities because that's based on the law. So if the law, as we see it, the law applies to cyber operation, and states which have taken the position that IHL applies to cyber warfare, the question is not renouncing the capabilities, is knowing, defining which capabilities are lawful or not. But those which are not lawful, they are already unlawful. It's not renouncing them to say they are unlawful, it's just applying the law that the states have already agreed upon. And then I take your point that saying, expressing a view that something is forbidden will not necessarily prevent your future enemy to think that this is not forbidden and do it against you. But still, it's how the law developed. It's through state pronouncements, certainly in terms of customary law. So I think that's also important to make other states aware of what are one state's position in terms of what is prohibited in cyberspace for the development, or the clarification of the law through interpretation by states.
Okay, quick question there, then over to Mike. Thank you.
Hi, sorry, good afternoon. Thank you for that presentation. Dr. Robert Dewar from the Centre for Security Studies at the ETH in Zurich. My question, I suppose, is directed at yourself, obviously, but I'd be interested in views on the panel. And I'm First off, I also agree that the Talon Manual is a very, very important document. It's a very useful document and sets a very beneficial precedent. But my concern is, and I suppose my question is, what hope is there for the applicability of IHL and, by extension, the laws of armed conflict as well, given that cyber itself is a hugely ill-defined term. It's one on which there's very little kind of conceptual agreement across certainly the academic sphere and by extension then the legal sphere. Is there a real hope or capacity for prosecution down the line, given that cyber has got such huge kind of conceptual disagreement?
On the question of definition, I don't think definition is a key issue in the sense that IHL applies whether you define it as cyber or as something else. IHL applies to any new means and method of warfare. You don't have the term cyber in any IHL treaty. So whether that falls under cyber, whether that falls under something else, the question is whether it has a violent effect, in which case, and it's linked to an armed conflict, in which case the rules under conduct of hostility applies to that, whether you call it cyber or you call it something else. Now, prosecution, there are certainly challenges linked to attribution, as mentioned before. That's the same for criminality in cyberspace. And again, I'm not a specialist, but I understand that cyber forensic is developing and that states are making lots of efforts in that regard, generally speaking, not only for armed conflict, and that's probably, that will also down the road, help attribution and possibly prosecution, but ICRC is not dealing with prosecution of individual case. We of course encourage states to apply IHL and including when there is war crimes to prosecute, as they must do under international humanitarian law and international criminal law, but we are not directly involved in that.
Thank you. And finally, Professor Schmidt, please.
So I'm Mike Schmidt. Laurent, I wanted to start by saying I agreed with every word you said when you said you agreed with the Talon Manual. So, so thank you for that. I have a technical legal question, Laurent, and it's a very important one because I agree with the ICRC that there are problems in the definition of attack. I agree with you and Heather and Kubo that there are problems with regard to the understanding of data. And so some time ago, I wrote an article in the Stanford Journal where I suggested that we should begin to protect essential civilian functions. I subsequently saw you guys, the ICRC, said essentially the same thing, essential civilian infrastructure, in your report to the big conference. And so I was excited about this. My question is this, though. When I made the suggestion, it seemed to me that we were talking lex ferenda, because it seemed that we were suggesting, or that I was suggesting, and the people that agreed were suggesting something about special protection under IHL. But the ICRC, taking essentially the same view, is treating it as almost lex lata, if I understand correctly. So I have a lawyer to very good lawyer, because we're friends and we've worked together for years. My lawyer to lawyer question is, how do you make the legal argument that there is special protection, which is an IHL term of art, special protection for essential civilian infrastructure, or alternatively, that essential civilian infrastructure should be treated differently than all other civilian infrastructure? I mean, I support you 112%, the ICRC view. I just think we're at lex ferenda, so I've been encouraging states to adopt policies, rules of engagement that take this on, so we can develop the state practice and opinion juris that will allow a customary norm to emerge. But you guys seem to be well out there.
On the question between lex lata and lex ferenda, I think the lex lata is that it's prohibited to direct attack against civilian objects, and the question is how you interpret that. And so in terms of interpretation, I think the distinction between lex lata and lex ferenda is not as marked as it is with regard to a specific rule. The rule is that it's prohibited to attack civilian objects. all civilian objects, all civilian objects. Now, on the special protection that you mentioned, we certainly, and I think the Italian manual did the same, see that data are protected as part of the special protection that exists in the Lex Lata for medical, the medical mission, I mean medical unit, medical transport, etc. That here there is a special protection. Now, in terms of essential infrastructure, we have not said that there is a special protection. I don't think we have said that. But I think it's very important to look at the effects, including in terms of, I mean, the first point is that civilian infrastructure, essential civilian infrastructure, as I said in the presentation, are primarily civilian objects. So they are protected by the prohibition to attack civilian objects. Now the question is, do we understand that data that are stored there and that are important for delivering services to the civilians are protected by the protection of civilian object or not? And we have not made the step of saying every single data is an object which is therefore protected by the prohibition of civilian object, but we have certainly made the point that interpreting the law in a way that allows targeting essential civilians data goes against the object and purpose of the law.
What's the legal argument for the word essential? Because IHL doesn't use this word anywhere except in special protections. So how are you treating that data different than other data? That's why I've come up with my lex ferenda, to solve this problem. How is the ICRC legally justifying the focus on the word essential?
You have special protection for some object. You have protection for object indispensable for the survival of the population. It's not the same word, I agree with you, but especially with regard to water, that would have an overlap between the two. You have also rules on assistance, which speaks of essential goods, so goods essential for the survival of the population. So you find the term essential in the provision on humanitarian assistance. Now, again, on the protection of essential civilian infrastructure, we have highlighted that as a particularly important issue in view of the effect it can have. And also, even if, again, the term is not there, if you look at the prohibition of indiscriminate attacks, it's those operations which might strike indiscriminately both civilians and military objective, and you look at the risk of effects. So the fact that you would have a widespread effect because it's an essential infrastructure is certainly also important in terms of the analysis of the law. Now, I agree with you that you don't have a specific special protection that would protect essential infrastructure or data that belongs to essential infrastructure. It's all the matter of interpreting how Lex Lata rules would apply in cyberspace.
You are a great lawyer.
Thanks, Mike. You too.
Thank you very much. Unfortunately, I see there's a lot more questions in the audience, but time is short, so we're going to have to draw your presentation to a close. So thank you very much again. It's with great pleasure that I can introduce our second speaker, Dr. Heather Harrison-Dinnis, who's a senior lecturer at the Swedish Defence University. Heather has vast experience in international humanitarian law and authored a leading text called Cyber Warfare and Laws of War, published by Cambridge University Press in 2012. Thank you very much, Heather. The floor is yours.
Thank you, Russell. You'll notice that I am not a lieutenant colonel at the US Navy War College. My name is not Jeffrey Biller. I'm Heather Harrison-Dinnis, and I come from the Swedish Defence College, as Russell said. There are two reasons for that. One, I'm a bit of a last-minute ringer. So on Monday morning, I had a rather stressed-sounding phone call from Thomas here at the CCD-COE saying, do you possibly have a paper you could give on cyber and IHL? And so I rummaged through my USB stick and said, well, I do have one on data as an object. Excellent, he said, present that. And as you see from the last question and answer session, it's still a very topical question. It's still a question that we're debating. So apologies to anyone in the audience who has heard this presentation before. This was initially presented a few years ago in Jerusalem at the Minerva conference, and in actual fact on a panel with both Mike Schmidt, who you saw offering a defense of his position there, and Kuba Matak, who's also in the audience. So it's looking at the definition of military objects and whether or not data can fall within that. The paper that this is based on, it's not in your book, unsurprisingly enough, but if you want to go and follow it up, then you can find it here. You'll also find the paper written by Kubo and a rebuttal by Mike. Both Kubo and I take issue with the Talon Manual position that data cannot per se be a military objective, and as you can see, that position is, and that argument is still ongoing. And one of the other reasons why it's still very topical is that the Talon 2 manual, which was just released earlier this year, has maintained that position, that data cannot per se be a military objective. And that's a position that I hold to be misguided and a little short-sighted. That's not to say that I don't think that the Talon manual as a whole is a fantastic product. It is. It's all right, Mike, I still love it. But this is one of the areas where I think they got it a little bit wrong, and even given the fact that they're looking solely at lex lata, at customary international law. So the paper that I'm speaking about is divided into four main topics. Of those relating specifically to military objectives, that is, to the legitimate targets of military operations, there are three interlinking parts to that question. The first is the question of materiality of objects. So whether something has to be a tangible, physical, solid state thing in order to qualify as a military objective. And this is where we will see, with the way that our network world is developing, that it becomes a really important question. Data-only attacks are the vast majority of cyber operations. So we need to think very carefully about what the law requires and what is a sensible interpretation for the modern world, where we're increasingly seeing virtualization of infrastructure. And this conference is all about protecting the core, protecting critical infrastructure. Well, a lot of critical infrastructure is actually virtual critical infrastructure. It isn't built well, it is built on solid platforms, but it exists as more than that. That's not to suggest that there is some cyber ether, to pick up on the question that was raised to Laurent earlier, but it's certainly more than the sum of its physical parts. This is what I want to discuss mainly today, this question of virtualization, of intangibility, and of data. But there's a couple of other points that I'd like to raise, and that are in the paper. You can read them further if you choose to do so. The second part looks at the way objects might qualify as a military objective with respect to cyber operations. And while most of them are fairly straightforward, the location criterion raises a really interesting question when it comes to cyber operations. So I'll touch on that briefly. And then the final part looks at the notion of the specificity that's required, the level of specificity at which parties are required to define the military objective. So this isn't a question that is unique to cyber operations either. We see the same debate taking place with relation to precision-guided munitions, when they become more and more available and can target very, very precise parts of buildings and other structures. For example, the exact room on the second floor of an apartment building from which attacks are being planned, instead of saying the entire building. Oh? And in the same way that these questions are particularly pertinent for conflicts fought in areas containing high concentrations of both military and civilian objects, in cyber, where much of the infrastructure and civilian and systems rather are dual use, the question gains extra salience. So when it comes to cyber operations, questions that can be expressed is whether there is an obligation on parties to define down the military objective to the smallest possible denominator, whether that be the entire network, a system within that network, a particular component, or even a section of code, and whether that obligation comes from the concept of the military objective itself, or whether it comes from the interaction of that definition with other rules of IHL, the rule on proportionality, the rule on precautions in attack. Or even from the more broader notion of military necessity. But the initial question that I want to begin with is one that everybody who looks at cyber operations and the laws of armed conflict has to grapple with at some point. Whether data per se can constitute a military objective. And as we've seen earlier, it's an incredibly crucial question because it underpins everything else. All of the questions about materiality, about qualification, about specificity, all boil down from the question of how we view data. So most discussions on the topic deal with data as a single entity. And as many IT specialists will tell you, well, it's all just zeros and ones. But in the same way that the two items up there are all just carbon atoms, and yet they are treated very, very differently. If you don't believe me, just try giving the one on the left to your partner. That doesn't mean that all data should be treated in the same way. And I think that's where a lot of us fall into a trap. I consider that it is useful to separate out two different types of data. On the one hand, there is content-level data. This PowerPoint presentation, for example, the paper that I wrote on this, the contents of medical databases, which Laurent mentioned earlier, library catalogs and databases, and on the other hand, operational or program data. And it's this second type of data that gives hardware its functionality. It's the operating system. It's applications and processes that allow the hardware to operate, to do what we require of it. So for ease of use, I refer to it as code. And it's code that is the soul of the machine. From a conceptual point of view, then, differentiation between these two types is important because of the different harm that results from damage. You saw the discussion here between Mike and Laurent just after his presentation about how do you deal with damage to different types of content data as opposed to functionality. You can see this playing out. If you accept that there is a difference between content-level data and program data and code, then that tension between these two positions falls away. Because while you can say, if you attack program data, you will cause loss of functionality, the same can't be said of attacking content data. Now, that's not to say that some content data isn't going to be specially protected. Medical records are the prime example. Medical records are protected under IHL, whether they're in solid state form or whether they're electronic records. In the same way, virtual cultural property is protected. It doesn't matter that it's a virtual reproduction. What matters is that it is cultural property. But content-level data doesn't necessarily result in functionality. It can be restored, loss of functionality rather. It can be restored from backups, and it can be recovered without much difficulty. And we see a difference, not that there is much state practice, but we see a difference in the way that states tend to react to these different types of attacks. If we look at the way that data-only cyber operations have been viewed, and remember that these are the vast majority of cyber events that we've seen to date, there is a difference. For example, website defacement, stealing or deleting of data, these are attacks on content data, which damage content, are viewed differently at a lower level compared with those that destroy functionality by attacking code. For example, wiper, the wiper or the copycat wiper Shamoon that attacked Saudi Aramco, we heard mentioned earlier this morning, were viewed very differently because they wiped the master boot record of the computers. The computers could no longer function. They destroyed the functionality. These were viewed very, very differently by those attacking them than when in the Russia-Georgia conflict, for example, someone attacked the website and put up a whole load of nasty pictures on the websites of the various parties involved. Take again the Ukraine power grid hacks. Here you're looking at destruction of functionality. Nothing blew up. They rewrote the firmware on the switches. Very cool, by the way. First time that's ever been done. In terms of technical ability, not in terms of actually, a moral judgment on the attack. But yeah. So we see a difference in approach, yeah, and how each of these two different types are viewed. So I think it's useful to start talking and start when we talk about data-only attacks to separate out these two different types. And if we agree that it is useful, then the importance of why we need to allow data to be viewed as a military objective is underscored by increasing virtualization. Services, systems, and networks. So this is the idea that virtual versions of operating systems, a platform, a storage device, a network, exists independently of the hardware on which it is located. Because the functionality is created virtually, it allows you to create different virtual machines running different operating systems, for example, running side by side on the same physical machine. Reduces the need for physical hardware, space, power to perform the same IT functions, and it's also part of the move towards cloud computing. So to give a very basic example, how many people here have an internet-based email account? Gmail, Hotmail, Yahoo? Yeah. Pretty much all of us. Most of us do. So do most corporations, or a lot of corporations at least. Academic institutions, governments do as well, and we use them all the time. That's a virtual service. You don't have that software sitting on your computer. It's located on servers in various locations along with everybody else's. Many of you may also log into work from your home computer, laptop, mobile device, over a VPN, a virtual private network. Virtual private network, huh? Extending your work's local area network beyond its physical location. So this virtualization trend is occurring not only for end-user services, but also for parts of states' critical infrastructure. We see it in power grids. We see it in telecommunications architecture, for example, for the very good reason that it produces massive gains in productivity and cost savings. We also see it in services that are not required to answer to their shareholders and governments, in military apparatus and systems, for example, for exactly the same reasons, massive cost savings. It can also make coalition warfare that much easier by allowing compartmentalized access based on different trust levels, different mission parameters. To give you an example, the entire US Armed Forces, as well as the rest of the US government, has been on a drive towards virtualization since at least 2010. Kudos to the Air Force, Mike, because 2009 they had their pilot systems up and running. They were the first in for weather forecasting and exercises. So this move towards virtualization compared with an increase in outsourcing and dual-use targets means that more of the data, processes, and codes that parties to an armed conflict might want to target with cyber operations are no longer tied to a single, dedicated, identifiable piece of hardware. As I mentioned, a single server or other platform might run multiple instances of an operating system, or indeed different operating systems, each dedicated to separate functions. And in the event that only one of those needs to be neutralized in order to achieve the aim of the intended military operation, the correct identification of that appropriate military objective for the cyber operation is determinative of that permissible damage to civilian objects when it comes to proportionality. Very briefly on content level data, because I want to concentrate mainly on code. Nice blue blinky light picture there. This is actually a Facebook data storage unit in Luleå in the north of Sweden. Just a point about content level data, we talk about content level data or some content level data being protected, It is, but it is also disaggregated. So it's not, we know armed groups use social media, for example. It's not like I can point at that blue blinky light and say, that is Kubo's Facebook profile. Kubo's Facebook, sorry to use you as an example, Kubo, but Kubo's Facebook profile is spread all over the place. Some of it might be in Sweden, some of it might be in Ireland. It's spread all over the place. So tracking down one particular part, if you need to find stenographically altered images, for example, coding inside images, if you need to find it, it's not necessarily all going to be neatly in one place that you can then target. Yeah, you can say, I'm going to take out that server right there. It's compiled, and what is it compiled by? It's compiled by code. It's algorithms that bring it all together. So you've seen this one in Laurent's presentation, Article 52, the object requirement. So this is bringing us on to this question of materiality. And as I say, I want to concentrate on this virtualization and materiality today. The first is the question of materiality, whether something has to be a physical, solid state thing in order to qualify as a material objective. And it stems from this opening word, insofar as objects are concerned, military objectives are limited to those objects. Now, for the majority of the group drafting the Talon Manual, the text, insofar as objects are concerned, meant that it had to be something visible or tangible. They were basing this on the ICRC commentaries. Therefore, for them, only hardware components could constitute objects and therefore be military objectives. And unfortunately, that perspective has remained in the Talon II manual, despite vigorous protests. So why is this flawed, misguided? The reason that word is in there, the reason that the ICRC commentary talks about things that are visible and tangible is that they were trying to separate out things from an aim or a purpose of an operation. So in World War II, we'd seen massive bombing campaigns that were targeting civilian morale, the population's will to fight, even amorphous concepts like victory. This was an idea of saying, no, a military objective is a thing. Visible and tangible, well, okay, it's not tangible outside the electromagnetic spectrum. Code isn't a tangible thing outside of the electromagnetic spectrum. However, it is visible. I give you Exhibit A. This is the flame virus, flame malware. You can see it. Of course, coders work with it all the time. That's how they code. You can't code something you can't see. So it is perceivable by the senses, if not physically tangible. Now, if tangibility is the requirement, then I agree that you cannot touch code. But you can certainly see it. You can certainly perceive it. The final point that I'd like to make is that requiring tangibility or materiality leads to a manifestly unreasonable result. And this is part of coming from sort of treaty interpretation. If something leads to a manifestly unreasonable result, then you can go back and look at what was the object and purpose behind it. And in this case, requiring tangibility ends up in a situation where you cannot target with a particular level of specificity because the entire physical object becomes the target. You cannot drill down to the lowest level possible. You can't send code after a cyber weapon, for example, because a cyber weapon exists only as code. And weaponry is sort of the par excellence example of something that should be a military objective. So a couple of other points. I consider that this approach to intangibility in the Talon Manual is sort of inconsistent internally within the Talon Manual itself. Certainly, there is no problem either within the Talon Manual or in general IHL as a whole with viewing weapons, viewing code as a weapon. We don't have an issue with that. We also don't have an issue with code being viewed, or intangible objects rather, being viewed as property. The Krupp and IG Farben trials following the Second World War were looking at stocks and shares and other property aspects of companies. Intangibility really wasn't an issue. So where it works for the law, where that interpretation is open, then states seem to be happy, and the law seems to be happy to accept that interpretation. There is a trend also in domestic law efforts to regulate cyber, and this links back a little bit to the question that was asked previously about prosecutions. This is still being debated by states at the domestic level, and yes, admittedly, we have to be very careful with applying domestic law by analogy. This is absolutely less ferenda, but we're seeing a flow in prosecutions in Europe and Japan that views virtual property as having real property rights attached to it. Not just intellectual property rights, real property rights attached to it. So for example, in Denmark, there was a boy who was playing in one of these virtual, I'm not sure which game it was, but it was an online virtual multiplayer game, who had some of his virtual property stolen. Well, the person who did it was charged with theft. Not with sort of any other tricky way around it, which other states have adopted. He was charged with theft. He stole property. So we're seeing a development of the law in Europe and in Japan, as I say. The US seems to be going the other way, but sort of watch this space, because a lot of our ideas about what we consider property and having real value, real property rights attached to it, will come out of our concepts of domestic law, what our domestic law states consider to be property. I know I'm out of time, Russell. But let me briefly go through this network location, because I know you wanted to bring that up. Military objectives are military objectives through their nature, location, purpose, or use. As I said at the beginning, most of this is uncontroversial. The one interesting point that I just want to raise, because Russell and I were talking about this beforehand, was this question of network location. Again, this is a lex ferenda point, not lex lata, but whether or not, by analogy, a particular node on a network could be viewed as a military objective purely by its location. Now, we know, following the leaks by Edward Snowden, that the NSA and GCHQ, for those of us who weren't intimately aware with internet architecture beforehand, have certain points where different networks join each other. Internet switches, gateway switches, that they want to monitor. So we know that they're of particular importance. The question is whether or not that network location can be seen as an equivalent of the mountain pass or defile in IHL. So in IHL, if you have a particular geographic location that by the nature of it, by its location produces an effective contribution to military action, trail through a swamp, mountain pass, whether or not that analogy can be applied to a network location. It's a gateway switch linking two different networks. There's an interesting question there about whether or not that can be a developing area of the law, and someone can target that based on its location. In practice, most of the time it will also qualify by its use. But for academics who like to pick apart these questions, then there's an interesting question there. For the rest, I suggest that you, read the paper. Handy link on the slides, and as I say, there you'll also find Kubo's paper, but you'll find a rebuttal by Mike Schmidt, which will hopefully mean he won't rebut too heavily now, and read the paper there.
Thank you, Heather. Thank you very much. Over to you, Mike. Okay, there's going to be plenty of questions, I'm sure, so let's go. So Mike, Kubo, and then the gentleman behind.
So let me speak generally about the Tallinn Manual, because this presentation bothers me in the same way many presentations and articles bother me about the Tallinn Manual. And the reason is because people keep talking about the Tallinn Manual position. Let me assure you,
I
as the
said
director,
majority,
that
Mike.
there is no Tallinn manual. Here we were very close. There was a majority and a minority. In this particular case, the majority, and it could have changed had there been just a couple of different people. A lot of us had military backgrounds, and so the majority won on this one, but it could have changed earlier. And we were very careful to set forth the alternative position. Indeed, the alternative position in this case takes up more text of the manual than does the majority position. And moreover, Laurent has mentioned essential data. The very first place that was mentioned was in the Tallinn manual in the minority position, because the minority said, even in the event that you don't accept, you're going to kill yourself. So even in the event that you don't accept the minority position, we take the position that essential civilian data that's essential to the civilian population, be accepted. The reason I'm very sensitive about this is because there are members of our group, world-renowned experts, and I don't want this position to in any way necessarily be seen as their position. There were people that agreed with your position and Kubo's position, even though they were wrong. So it happens to be my position, okay? It happens to be my position. I'll tell you exactly how we figured it out. Yes, we went off looking in the ICRC commentary. Yes, we knew at the time, we had pretty smart people, we knew at the time that we were not adopting the ICRC commentary text in the manner in which it was intended. Remember, the ICRC was with us at every step of the process. So we were acutely aware of this. I'll tell you how we decided. We're kind of simple people. There were some computer nerds with us, okay? PhD in physics, scary little guys, pasty face, big thick glasses, that kind of guy. And I said, listen, I need to know if this is an object. So, dude, put some data in my hand. Now, I don't care if I can really feel it, but I want you to put data in my hand. Because you know what? You put it in my hand, I know it's an object. And it was clever the way you put up the code, but I can put a mathematical code on a blackboard as well, and it's not an object because you can see the mathematical code. So I would remind you, Heather, that we were interpreting customary law. We were not interpreting treaty law. You've suggested a manner of interpretation that's consistent with treaty law, so let me walk you through it, and I'll tell you what the thinking was had we been, in fact, interpreting the treaty law instead of customary law. First, in your interpretive approach, you say that if it leads to a manifestly unreasonable result, you must look to the object and purpose. For treaty law, I happen to agree with it. And by the way, I happen to agree that the conclusion of the majority, that would be my group, leads to a manifestly unreasonable approach. But I also happen to believe that the position of the minority leads to a manifestly unreasonable approach. Why? Because in the military, we have been conducting these operations against the civilian population for some time, actually in cyberspace. And before cyberspace, we were conducting these sorts of operations all the time. They are known as psychological operations. We have entire units, and no country in the world believes that a PSYOP conducted against the civilian population in and of itself, per se, is unlawful. So yes, this approach leads to a manifestly unreasonable approach because the civilians suffer unnecessarily and in a way we would all agree was wrong. But so does yours. And so the flaw is when we get to this point with two manifestly unreasonable approaches, what we must do is look to object and purpose, and this is where you made your error. The object and purpose of international humanitarian law, or the law of armed conflict, or the law of war, is not solely to advance humanitarian purposes. This is well established, accepted, I believe, Laurent, correct me if I'm wrong, I believe accepted by the ICRC. The object and purpose of international humanitarian law is to find an appropriate balance between military necessity, the concerns of military necessity, and humanitarian considerations. Because remember, the law of armed conflict, humanitarian law, allows you to knowingly kill civilians who have nothing to do with the conflict. And so I agree that my approach comes up with a bad result, but so does the other. Your approach runs counter to state practice, it runs counter to opinio juris, It is a manifestly absurd approach from the perspective of military necessity. Hence the work the ICRC is doing. I applaud them on this. It is because of this problem that the ICRC, and myself and other scholars around are saying this is an unacceptable situation. Let's work ourselves out of this problem. Now, Laurent suggests a slightly different approach than mine. I don't agree with your legal analysis. I agree absolutely with your result. That's my approach. Maybe you think I'm off because I don't admit the lex lata status yet. But this is how we get out of the problem. This is how we get out of the problem. But let's not just throw the baby out with the bathwater, which my approach does, and so does yours. Let's work towards a solution.
Heather.
I think that's a question.
Yes.
I would have another word. But no, Mike, let me be very, very clear. I don't agree with the minority view in the Talon manual either, and I was very, very careful in my presentation to say the majority of the Talon group, because I know that's a particular sensitivity. So let me defend myself on that. I was very careful about that. I also disagree with the minority position, because I think it opens the door far too wide, and we're in complete agreement that the object and purpose of IHL is to find the balance between military necessity, not only humanitarian protection. That was Laurent's speech that you were quoting there rather than mine. So we're in absolute agreement about that. What I think is the solution, as I said in my presentation, and that I focused on mainly here, although I mean I know you've had the benefit of reading the paper, is that the separation of different types of code is perhaps the way forward, because you guys, if I may put you in the minority, because the ICRC was there, you guys agree on functionality. You agree the destruction of functionality is unacceptable. Where the problem comes down to the approach to content level data. And frankly, I don't really address that in my paper. I didn't really talk so much about it there, because I think there are other ways of dealing with it, and to me, code is more interesting. So because it comes down to the functionality. So I strongly push back on that. I don't think that you can say, well, I don't think you can put me in the minority view camp, because I'm not. I don't believe that the minority is correct, because it is far too broad. But I also think that finding that distinction between different types of data is the way forward. You can't just apply a one-touch-fits-all approach when it comes to this.
But we did find precisely that definition, working closely with our friends in the ICRC. The ICRC did not take a position on anything in the manual at the time.
No,
they
I know.
simply provided advice. But working, I will tell you, it was Cordia Ladroga. She was brilliant. She and I had conversations back and forth, and it's out of those conversations that functionality came. And functionality is all about data essential to the operation of the machine. So the only thing left was in fact content data. So the manual is talking about content data, although within the group accepting functionality, there were various views. I took a very liberal view, and my friend Wolf von Heinig took a less liberal view, you can imagine, on this. But we had accepted data affecting functionality. We were quibbling around the margins. It was all about content data.
But the problem that you've got, Mike, with your view is if you have multiple instances of a machine running on a single physical platform, destroying the functionality of one of those operating systems doesn't necessarily affect the physical hardware underlying it. And yet the majority position in the manual requires destruction of functionality of the physical.
No, there we were divided. And by the way, that is not my view. You see this laptop? Okay? I don't really care how it stops running. I just don't care. If it stops running, it stops running. For Mike Schmidt, what I distinguish between is a temporary interruption of a DDoS sort of thing for a short time, and it doesn't stop running. But I don't care if it's because I have to reload my operating system or data essential to the criticality of this particular is gone. I don't care. I've written about this in the review of the Red Cross because the ICRC convinced me in a very famous article many years ago called Wired Warfare. They convinced me I was wrong. And so I rewrote the piece to make exactly this argument. The ICRC is right. If it doesn't stop, if it doesn't work, it doesn't work. You don't have to think too hard about this in life. But perhaps Russell's given me the eye.
I think we should allow Laurent just to comment briefly because he was implicated in that. But
talking about
that's
you.
going to have to be the last point, and then we'll have to move on, I'm afraid. Laurent, briefly.
To react to one point you mentioned, Mike, because you said you draw us in when saying the object and purpose is to find an appropriate balance. We see the object and purpose of the rules governing the conduct of hostilities to protect civilians by finding an appropriate balance. You might say it's a distinction without a difference, but I don't think so. I think it gives a different perspective on how you have to do that, and that's in terms of treaty law, at least, that's clearly based on the title of the relevant chapter and Article 48. So we view the object and purpose to protect civilians by finding an appropriate balance between military necessity and humanitarian consideration.
Thank you, thank you. I saw there was lots of other questions. Unfortunately, we're going to have to curtail the discussion in order to allow sufficient time for the last speaker. So let's thank Heather once again for a very interesting presentation. And I would like to introduce our final speaker, Tassilo Singer, who's a research associate from the University of Passoa, who's very close to finishing his PhD under the auspices of Professor Wolf Heinzhed von Heineck, and you're welcome to the floor. Thank you.
Thank you. So good afternoon. We'll follow my PhD supervisor, Professor Wolf Heinzhed von Heineck, and doing a Prussian force march through my presentation now so that we can finish early. I will skip the structure because you will see it anyway on the top level of my presentation. I'm going to talk about a problem concerning autonomous cyber weapons, meaning cyber weapons that work themselves their way into the target and that can destroy or harm a target themselves. I will skip the general part about direct participation in hostilities. I will just show you as a basis the rule we will be talking about. And that's the important part. Civilians shall enjoy protection unless and for such time. Remember this one. This is the important part. Unless and for such time as they take a direct part in hostilities. So in practice, there are several problems about it. The wording is not that precise, and that's why the ICRC made an interpretational guide where some international experts moved out because of some other issues. But basically, the consensus is that these three criteria have to apply for a direct participation in hostilities: threshold of harm, causal link, and belligerent nexus. Of course, the content is a field for heated discussion. That's what I mean with critique. But we have a general consensus. So, we have a different issue too, and this concerns the time period. I will just put this up here. How long does the period of time for a DPH by a civilian extend from a legal point of view? This problem is already existing in regular situations. Just compare the problem to the Afghanistan farmer, who's a farmer by day, but in the night he takes out his gun and he's doing ambushes on ISAF troops, for example. You have a problem. How long can you attack this guy? Of course, you can attack him while he's shooting at you. No discussion. But what's afterwards? When do you stop to attack him lawfully? Because he's taking away the weapon, and then he's the farmer, the peaceful farmer. He never did anything wrong. So what time do you have? And this is a problem that's existing already without autonomous cyber weapons. And so I'm skipping there. You have three acts basically, but that's totally logically: preparation, the act itself, and the return. So I'm skipping this and going now to autonomous cyber weapons. Their characteristics are that there's autonomous command and control. The activation and the damage is at a future point without human interference, and the start of the cyber tool and the occurrence of the damage regularly differ in time. Why? Because otherwise, it won't be an autonomous system. If there's a human control all the time, then it would be a regular cyber weapon you're using. Because if you control it, there's no autonomy in it. And that's what I mean by autonomy. It's about a self-functioning system that's working in your computer programs, in your computer networks. So an example, and you can find this in Talon 1.0 and I think in Talon 2.02, that you have these delayed cyber attacks and logic bombs. A fairly easy example is that you have a worm in your computer that activates at a certain point of time. I don't know, 20th of April if you have a German Nazi attack or whatever, you know? So at this moment, the cyber weapon switches on and starts its destroying work or whatever it's doing. It could be everything. But at this moment, no human is acting. So now transfer this to a civilian using such a weapon. He will prepare its weapon, probably offline, otherwise he would be stupid, and then start the weapon via, for example, pressing once enter or inserting the USB stick, whatever method of appliance. And then he stops. And so think about the farmer who puts down his gun and walks home and is farming again, being peaceful. And then suddenly, a month, a week, a year later, the weapon starts to work and does its damage. At this moment, the civilian is totally protected by law if you follow the narrow interpretation. And now, my game is getting on. I will just skip to the solution.
You have time, you have time.
Yeah, but I think we will go to the discussion. It's going to be more fun. So my proposal for a solution is, and now I will watch all of your faces, we're going very critical. My proposal for a solution is that you extend the time period you can attack such a civilian. But let me be careful, I will bring it up again later when I give you my arguments. Of course, the civilian has always the possibility to go to relevant authorities and say like, oh, I did something bad, I started a cyber weapon, and so on. Because I think you can expect this of someone who harmfully prepares a weapon, inserts this weapon, and then says, oh no, now I want to be protected again, I want to be happy now, and you know, I will be peaceful. Of course you have to expect this from this person. You cannot protect him over and over and over when he does such acts. I mean, we're talking about, and that's the important thing, about DPH, and that means DPH is threshold of harm. There has to be a certain level of harm, and a civilian who does such harm is not a protected person. There is a bad intent behind this. Of course, I'm not talking about bad intent in a legal sense, but think about it. And now I'm going to possible critique, which will definitely come from this side. And you don't need to say anything because the critique is already written down in your interpretive guide, which says any extension beyond specific acts would blur the distinction in IHL between temporary activity-based loss of protection due to DPH and continuous status or function-based loss of protection. Sounds bad, doesn't it? The duration of DPH will be restricted to the immediate execution of the act and preparatory measures. But, you know, if you're not stupid, you're doing it offline, secretly in your chamber. So preparatory measures are a bit difficult to detect. Also, of course, a narrow interpretation of the rule increases the protection of civilians. Always good to protect civilians more. And you can always, and this is again a discussion that had been happening in the interpretive guide, you can always capture the person and get him to prison and so on. That's also a big argument. And then again, and now think about it, they compare it to a mine layer, which they also hold that he cannot be attacked after he laid his mine, because the mine is there, the person is years away of it, and then the mine suddenly detonates. So this is the critique I'm expecting. And of course, a bigger issue, you could argue that there is no military necessity. So there is no military advantage of attacking the civilian afterwards. But let me tell you, all of this is wrong. Think about it. The execution phase can encompass the periods over which malware is installed or deployed, or over which the targeted systems are compromised, or the victim actually suffers the effects. You know why I have these footnotes there? It's from the ICRC guide. They wrote it down too, and they include this. And now transfer it to autonomous weapon systems. It's exactly what they're doing. The malware is installed or deployed itself because it's autonomously working. The victim actually suffers the effect. That's the moment when the weapon shows its damage and its damaging effects. So, of course, the execution phase that is criticized, the specific act, can be the autonomous weapon system working. I will also add another argument later. Also, the wide interpretation I'm giving has the purpose to sanction and deter civilians to directly participate in hostilities. Just let me come back to one point, and also Mike quoted it before, as a basis of IHL. The balance between humanity and military necessity is a very core part. And now think about the rule of Article 51.3, which is exactly representing this balance, because it says as soon as the civilian takes up a weapon and changes its role in the armed conflict, he is not or she is not anymore protected. And this is exactly this balance we are talking about. And now think about a civilian that is using such weapons, that work autonomously, that he's using exactly that tool, but then we are arguing totally different and say like, oh yeah, you can attack him while he's pressing enter, but afterwards not. And still, the action is ongoing and ongoing. I'm not talking about a quiet object. The code is still working. It's waiting for the condition to start. Also, the narrow interpretation privileges civilians using autonomous cyber weapons. You know what will happen? As soon as you argue the civilian that this interpretation has to be narrow at all points, well, then have fun with able Taliban or ISIS fighters who might be able to work with such weapons, or they buy it in darknet, and then they will just continuously use autonomous cyber weapons because they know they just have to be quick. They just have to press enter and then just leave the room. That they are protected again. So think about the repeating factor. Furthermore, think about the capture or kill argument. I think everyone knows about this, and there are the classic counter arguments. You need territorial control, or you have to be capable somehow to get the person, and then you need the cooperation of the state. I think it's not practical. And now, concerning the situation of a mine layer. I just have to get to my papers because I want to be very clear on that point. Autonomous cyber weapons are entirely non-physical. The actual activity of a civilian cannot be supervised as a mine layer potentially could be via a drone or whatever. The activation of a mine to produce its effect is physical, in contrary to an autonomous cyber weapon, which is purely digital and does not need a separate act of activation. Think about a mine. A mine needs any physical thing to get off, or a timer, at least. Also, the acts and effects of a cyber weapon are digital, and only the consequences can be physical. The whole possibility of perception of the civilian acts and the weapon itself differ widely to a mine layer, though. Therefore, in my opinion, the comparability is only very abstract. It might look like the same situation, but I'm arguing that it is a total different thing if you look at autonomous cyber weapons. I will get to an end now. The military necessity, from my position, is at the core of IHL. It's about reaching this balance of military necessity and humanity. And as I told you before, Article 51.3 is perfectly representing this careful balance. And someone who's using an autonomous cyber weapon is harming and interfering with this balance. As I told you, he would be legally privileged. He would be supported by the law even if he did something wrong. And this means threshold of harm might be sinking your destroyer or whatever, if he's able. Also, and now I will get a bit narrowed down anyway, there is no unlimited extension due to the necessity of the prevailing cumulative criteria for DPH. Of course, you need threshold of harm, the causal link, and the belligerent nexus. So, of course, it would not make sense if no armed conflict anymore is prevailing to bomb this person. Of course, then you have to rely on criminal prosecution or to attack this person. Autonomous cyber weapons act as a prolonged arm of the civilians. That's the core thing about autonomy. You're using a tool that's working for you exactly as you want it to be, or maybe unintended. And it would be an unjustified legal privilege of a civilian using autonomous cyber weapons. Think about equity, you know? And then again, you need an in-depth knowledge, and the guy who uses such weapons that can work autonomously without any additional help creates a certain risk. And think from a legal perspective, you have in different legal systems, you have punishments and so on for creating certain risks that are held very dangerous for the society or for certain legal goods. Okay, and as I told you before, there is always the possibility to retreat for the civilian and regain protection, because he can inform the relevant authorities about his act, and then he has to face criminal prosecution. But didn't I remember that also the narrow interpretation would go for criminal prosecution? You see, that's nothing that sets the civilian less good than in the narrow interpretation. And you have to think about the objective perspective of the victim state. The victim state will get attacked. Do you think they care if it's autonomously or if there's a civilian in the back? The perception will be we are getting attacked and we have to do something about it. And actually, gray areas, and that's how I'm concluding, should be interpreted in favor of DPH to enable clear distinction between combatants and civilians. Please think about a civilian that takes up an arm and joins the fight. Do you want to privilege such a person? Is this the sense of the rule? In my opinion, no. So I'll just put that up, and I'm happy to get your questions.
Okay, right, there's going to be some questions. So let's go through these quickly, because we're shortly running out of time. Kubo, then over there, and then back there. Quick questions, please.
Quick.
And then Laurent, too.
Thank you, Tassilo. Very interesting and I would say provocative talk, and I think you intentionally led it in that way. So let me throw it back at you. I mean, to me, even though you have a long list of arguments and they're all very interesting, to me the key question is the interpretation of the law as it stands, and the key question there is whether the activity in question has been completed or not, whether it is still ongoing or not. And so that's why I would put it to you, it is analogous to mine laying. And if you look at the ICRC reports that led to the adoption of the DPH study, they considered mine laying, yes, that's direct participation, clearing mines, yes, that's direct participation, but the person is not directly participating once the activity has been completed. So that is why I would put it to, it is analogous, and it does not matter whether the effects are in the physical space or in cyberspace. And if there is a difference, the onus is on you to prove that, and it's not enough to just say that the effects are physical or not. That's not enough to distinguish it from the situation of the mine layer, which you correctly pointed out as one of the counter-arguments.
Okay, I'm answering really quickly. From my perspective, it is a difference because the mine is standing still. It's a fixed object. An autonomous cyber weapon is working, it's moving. And that's a very short answer. We can discuss that later. But that's my difference. I see like the autonomy is the peculiarity that allows the legal difference.
Okay, thank you. There's a question just there. Introduce yourself.
Thank you very much. I'm George. I'm a student of University of Glasgow. So 2 remarks and like questions. So I don't think that Taliban and Al-Qaeda, for example, can enjoy this civilian protection because they obviously organized armed group. So how you answer that? And the second one is, what level of autonomy of weapon are you talking? Because if it's fully autonomous, how you command the mens rea requirement for like putting this? How you can basically convince a person which didn't have intent if its weapon is fully autonomous? Thank you.
I can answer this very quickly. Sorry for quoting the Taliban. Of course, organized armed group. It was just an example during my fast speech. Just think about really a total separate civilian without being in a hierarchical structure and so on, okay? Just to make it clear, you're right on that point. Secondary, if you talk about fully autonomous weapon systems and mens rea, you might be right. But actually, I have not seen any mens rea requirement in the DPH criteria. There is no such a requirement. We are not talking about international criminal law. But would you deny a mens rea when someone uses such a weapon and programs it and then starts it? You would deny that there's mens rea when you press enter and send the weapon out? Well, at some point, you're asking the question if the egg was there before. At some point, this has to be prepared and started by someone. Otherwise, it appears in the air, and that's not realistic.
Okay, we'll have two quick questions there, then last question to Laurent.
All right. Augustine Marinello, U.S. Naval Academy. So it's 2007. I control a very powerful botnet, and somebody hires me to help DDoS Estonia. In that scenario, am I liable to be? Is attacking me, blowing up my laptop, justifiable under what you say? And then conversely, let's say I haven't activated my botnet to assist in the DDoS attack yet, but you have intelligence that indicates that I'm in the process of negotiating or accepting money from some other entity to activate my botnet to attack a target you may hire me to attack. In that second scenario, am I liable to be attacked? Thanks.
Okay, well, if you're directly controlling it, I mean, that's straightforward, that's a DPH. But in the second thing, well, first of all, I would ask you, well, how close are your connections to that state or whoever who's hiring you? Maybe you're an organized armed group, or you're a combatant because you're on the payment role. Well, but if you're totally freelancer and someone goes to you and say like, okay, let's do autonomous cyber attacks. In my opinion, you're liable for that because you're creating a danger that is out of there. Well, if you're in a negotiation process, it depends how far your weapon is. Think like the preparation process. That's really important. Of course, you have to be strict. Well, and actually, that's why I think you have a problem in the preparation process if you would think about lawful targeting, because when would you think an autonomous cyber weapon is ready? Maybe I just downloaded it purposely, or I was in dark web and thought like, oh, this sounds interesting, and then I realized, oh God, what have I done? Am I already can I already get attacked? Is the danger that real? And I think at this point in the preparation part, you have to be very, very restrictively concerning cyber weapons. Very, very restrictively.
Okay, Thomas, we have one final remark do we have enough time? Yes. Just one very quick final remark, Laurent, and then we'll conclude.
I will try to be very quick.
Please.
I think the first point is the ordinary meaning of the word. The exception, as you recalled on the slide, it's for such time as the person is taking part in hostility and not for such time as a weapon is operating, which is what you suggest. That's not the ordinary meaning of the term for the rules on DPH. It's not reconcilable with the object and purpose, which is to protect the civilians by finding an appropriate balance. In your response to the critics, you seem to say that the purpose is prevention of attack. I don't think prevention of attack is the purpose of DPH. I don't think that's in no commentary, and that's, I think, a very dangerous path to take to say that you can target somebody to prevent a future attack, except during preparatory acts, of course, because then you are preparing the attack, but just to prevent that the person would redo it afterwards. It's not based on state practice. I think Kubo explained it well, why it's state practice with mines, and you try to counter with saying it cannot be supervised, for example, by a drone. But let's not forget that the rule on DPH has been established in '77 when there were no drones. So supervising somebody during the night hiding a mine below a road was probably as difficult as today supervising somebody making preparatory acts on internet. So I think here the distinction again is not valid. The military necessity, you mentioned yourself, that's a problem in your paper. you actually dismiss the possibility to capture exactly for that, because you conclude your sentence that capturing, I quote, does not counter the threat of continuing autonomous weapons. And I think that's exactly also the case for killing. So there is no military necessity in killing. The only answer is to target the system, the object itself, the code, the network, whatever, the weapons you have used. That remains a military objective as long as it is operating. That's also your conclusion. I mean, that's mentioned in your conclusion on your paper. One last point on the civilians going to expose himself and tell the authorities that he has done that. I think that's a misrepresentation of what civilians can do during armed conflicts. Often civilians, they don't just want to take any part in the conflict. They might just be willing to the conflict to be stopped, and they might be forced to do something. And now, if they go to the other side and tell, look, I have done that for one party, of course they will face retaliation by the party in favor of whom they had DPH'd before, so that's totally unrealistic. And then let's take the scenario again of the Ukraine electricity grid. And let's assume, I don't know, that Ukraine got some support from an IT company to protect its electricity grid afterwards. And let's suppose as well that the electricity grid had some sort of a military objective, so that was an attack, and then defending a network against an attack is DPHing if the attack is lawful. So you mean that the IT guy, let's say Microsoft, who helped set up a defense system for the Ukrainian electricity grid that would include, let's say, hackback, automatic hackback, would be DPHing until the end of the conflict unless he tells the Donetsk authorities that he has done that? Come on. No state will agree on that.
Okay.
Okay. Very quickly.
So, so within
I have
30
to
seconds,
sorry,
30 seconds, then we'd have to call it a day.
I have to hack back. Do you think that to hack back already fulfills the threshold? Just think about the level technically, what you have to do to stop that attack. I don't think that you necessarily fulfill this threshold. You can discuss about it, but I don't think you fulfill the threshold. And secondarily, that's my last sentence, and I will answer with the ICRC's interpretation of international law. As we've seen before in your discussion with Mike Schmidt, you had a wide interpretation on essential civilian infrastructure in contrast to all civilian infrastructure. DPH is not interpreted, in my position, as wide as reading a different word in it, because from my perspective, it's the direct part of taking part in hostilities is the autonomy of the system. It's the prolonged arm, in my opinion. Sorry?
That's the weapon, not the person.
Okay, well, thank you very much, speakers. I'm sure this is going to carry on over the coffee break that we have. Let's conclude. Thank the speakers once again. Thank you very much.